G'day, I'm Stephen Page from Page Proven Family and Fertility Lawyers, and you're listening to the Australian Family and Fertility Law podcast. And today I just want to talk about a recent case decided in the Family Court, or as we now call it, the Federal Circuit of Family Court of Australia. The case called Lloyd and Compton, the judgment delivered in late January, concerned a Queensland couple, husband and wife, who went to North Cyprus for surrogacy. They had a surrogacy agency not from North Cyprus help them with their journey, and at the conclusion of their journey to parenthood, they had a baby. But then the problems started. The first problem was that under the law of North Cyprus, remembering that the Turkish Republic of North Cyprus is not recognised by anyone other than Turkey, but under the law of that place, which Australia doesn't recognise, a birth certificate issued in which the intended father as the biological father and the birth mother, namely the surrogate, were identified as the parents. Critically, the intended mother was not shown as a parent. How to fix this problem? Well, the obvious way of fixing it, which seemingly is too hard to do over there, is over here to obtain a step-parent adoption. Now, in Queensland, that can't be done until the child is 5 years old, at least, as set out in Queensland's Adoption Act. But in any event, before that is achieved, then ordinarily a step-parent adoption needs leave to adopt in the Federal Circuit and Family Court of Australia. It sounds pretty odd that you go off to a state or territory court to obtain a step-parent adoption, and you go to a federal court, Federal Circuit and Family Court of Australia, to obtain leave to adopt. Essentially, it's an anti-avoidance provision under the Family Law Act. And that came about 30 or so years ago when a couple of women discovered, to their delight, that adoption was a state and territory responsibility, whereas divorce and custody were federal family law responsibilities. There's an exception for Western Australia where it's all done under the one roof, but everywhere else it's split. And so they came up with the brilliant idea that if they married their partner and their partner did a step-parent adoption, then he would be the new parent and the father of the children, their ex, would be cut out. So as a result of their actions, the Family Law Act was changed to ensure that step-parent adoptions are obtained. That leave to adopt is obtained before a step-parent adoption is obtained. There is an exception to that rule, which is if you've got a parenting plan in place that gives both intended parents the parental responsibility for the child, then leave to adopt is not required. But that wasn't done. So a lawyer in New South Wales then made an application to the Federal Circuit and Family Court of Australia. And what was sought was, in essence, a variety of orders tagged to the important one, which was leave to adopt. Sadly, none of those were granted. Justice Carew, sitting in Brisbane, was alarmed that this couple had, on their own admission, engaged in commercial surrogacy in North Cyprus. It is an offence for anyone living in Queensland, or for that matter, the ACT or New South Wales, to engage in commercial surrogacy overseas. And it is an offence for anyone living in the Northern Territory, South Australia or Western Australia to do it in some circumstances, what's called a long arm law. And if anyone living in any part of Australia engages in adoption overseas, that is the form of surrogacy, and that happens in some places, and there's a payment in consideration of that adoption, then an offence can be committed here under the relevant Adoption Act. So the admission was made, The judge called, according to a judgment, for submissions about who was a parent, but really the submissions were quite lacking. The evidence produced by the lawyer was quite lacking. And the outcome, well, the couple didn't get anything that they wanted. It was a complete own goal, but worse than that. Her Honour referred the couple to the Queensland Director of Public Prosecutions for consideration of prosecution of the offence of engaging in commercial surrogacy overseas. And so far as the lawyer is concerned, they didn't get off scot-free either. The lawyer was referred to the Legal Services Commission of New South Wales for procuring and filing an affidavit evidencing the commission of the offence of entering into a commercial surrogacy arrangement overseas by Queensland residents and for competence. Her Honour asked for certain evidence. The evidence simply wasn't provided. As an example, the lawyer gave evidence in her affidavit as to the law of North Cyprus, even though she was not admitted there, and without setting out the law in black and white. So anyone who is contemplating undertaking surrogacy overseas ought to get really good expert legal advice before they do so. In my case, I've given advice since 1988 in over 2,000 surrogacy journeys for clients throughout Australia and 39 other countries, more than any other lawyer. But get the advice, don't commit the offence. So far as the couple are concerned, the judgment, however, has a glimmer of light. It's unlikely that they will be prosecuted. And that's not just because in the past, no one has been prosecuted for this offence anywhere. Since these surrogacy laws came into existence in about 2010, Queensland had an earlier version since 1988, and no one was prosecuted for going overseas in that time. It's because the offence in Queensland has a time limit for prosecution, and it's a year. The judgment shows that the surrogacy arrangement was entered into in 2023. By the time the judgment was delivered in late January 2025, that time had expired. So if you're contemplating undertaking surrogacy overseas, get good advice first. Don't be one of those people who are extremely stressed because a judge has referred you to authorities. Don't commit offences, comply with the law, but if you get good legal advice, you should be able to become parents without too much difficulty. Thank you for watching and listening. I'm Stephen Page from Page Proven Family and Fertility Lawyers. This is the Australian Family and Fertility Law Podcast.